Welcome to the Law Awareness Weeks at CDC 2025. This webinar is part of Law Awareness Weeks at CDC 2025. It is a collaboration between Pro Bono SG, the 5 community development councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. I am Chiang Ming, and I am your host for this webinar. Today's webinar is Neighbours in Dispute. What are my options? As you can see on the slide, we have many webinars coming up. If you are interested in any of the upcoming webinar topics, you can click on the link shared in the chat function to visit the website https://go.gov.sg/law-cdc. That's https://go.gov.sg/law-cdc. Okay, you can click on the link to register for the next webinar or the many more webinars available. First, some housekeeping matters. Today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also upvote on any questions that interest you. Secondly, if you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is LAWCDC2504, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you are viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. And thirdly, please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. And with that, I would like to introduce our panelists for today's webinar, Mr. Melvin Low and Ms. Katherine Yap. Melvin Low is a senior lecturer at SUSS, teaching conflict resolution, mediation, and criminal law. A CPR Outstanding Professional Short Article Award recipient, the first from an Asian journal, and SUSS Excellence in Teaching awardee. He's recognized by the State Courts, Singapore Mediation Center, and Pro Bono SG. He serves on several key committees, is a SIMI certified mediator, and counsel at Peter Low Chambers. Ms. Katherine Yap is founder and chief executive at Rafa Mediation Private Limited. She is a certified mediator at the Singapore Mediation Center and the Singapore International Mediation Institute, and a master mediator at the Community Mediation Center. In 2009, she spearheaded the launch of Maxwell Chambers in Singapore, the world's first alternate dispute resolution complex. Melvin and Katherine, thank you for joining us today.
Thank you. Thank you.
Now, disputes between neighbours are a perennial problem in Singapore, whether they are over complaints of noise, secondhand cigarette smoke, or bulky items placed along common corridors. If you have joined our webinar today because you are involved in a dispute with a neighbor, or know someone who is, or just want to know more about what your legal rights are and what goes on in a dispute, just in case you might get involved in one, please stay with us. This evening, we will be looking at these issues and how they can be resolved. So let's start with Melvin. Melvin, can you tell us what forms the legal basis for making a complaint against a neighbor?
Right. So let's start with the basics. I think when we speak about mounting a claim at law, we're looking for what we call essentially the heads of action or rather the cause of action, excuse me. And the first one to speak about is that of the statutory tort of unreasonable interference. So basically, when we say unreasonable interference, this is under the Community Disputes Resolution Act, and this involves excessive noise, smell, smoke, light, or maybe even vibration, if you will. Right? And then the other one that is often spoken about is that of the Protection from Harassment Act, or some of us may know it as POHA. So in the situation where we're dealing with neighborly disputes, POHA is for dealing with, for instance, repeated or excessive, I would say, harassing or alarming or distressing behavior between parties. The other thing that I would like to share, since we're speaking about the legal landscape as a whole, is let's speak about some of the recent enhancements that have been introduced from the Community Disputes Resolution Amendment Act 2024, which include mandatory mediation, as well as a new unit that's been set up called the Community Relations Unit. So first, about mandatory mediation. It's a key change because it introduces what we call a mediation direction. And what happens is now that authorized agencies can now direct parties in a neighbor dispute to attend mediation at the Community Mediation Center, also known as CMC. And this actually is quite a big change from previous, I would say, understandings or formats of mediation, because previously it was that of a voluntarily only model. And this shift is basically to try and get disputes resolved before they escalate to the courts. And primarily, when we say the courts, we're speaking about the Community Disputes Resolution Tribunal, or CDRT. Important to note also that the failure to comply with a mediation direction may have legal consequences. Now let's move on to the next thing, that of the CRU, or the Community Relations Unit. So the recent amendments through the CDRA actually provide for this establishment of this new unit, which right now is in its pilot phase. They're running the pilot in Tampines, and it's meant to essentially, over a 1-year pilot timeframe, address a number of, I would say, small minority of severe intractable disputes, especially those involving noise or hoarding. So the CRU actually has powers to investigate and take action in particular severe cases. All in all, this actually is taken together with the enhanced powers of the CDRT through the courts, and these amendments actually allow for the enhancement of processes and powers of the CDRT if it really comes to the point where neighbors require the court to issue orders. And some of these new orders, for instance, include interim orders, as well as or rather interim orders which can actually help provide a quick resolution of urgent situations until the case is actually resolved as a whole. One final point about the changes that have come about or will be introduced, the CDRT will be able to consider all relevant evidence gathered by the CRU officers, right, which will help facilitate more effective resolution of cases, which hopefully help parties reach a more meaningful and sustainable resolution.
Thank you very much, Melvin. Let's now turn to Katherine. Katherine, what can you tell us about the dispute resolution framework and the various dispute resolution bodies?
The Community Disputes Management Framework was established in 2014. That is to promote a gracious and harmonious living environment for all. However, the CDMF has been enhanced after extensive public consultation, and there are some new introduced methods to the whole entire framework, which is now under the pilot phase. So to begin, we have a couple of community mediations centers. We have also Singapore Mediation Center. We also have Singapore International Mediation Center that support this entire system. So for the CMC Act in 1997 is established to offer an accessible, affordable, non-adversarial way to resolve social and community disputes, aiming to keep matters out of court and preserve relationship. Now, following 1997 policy recommends to promote amicable settlements for neighborhood and relational issues that do not involve arrestable offense. The role of the CMC is providing the voluntary, neutral, facilitated mediation to rebuild communication and craft practical agreements that parties can accept, preserving neighboring ties under the enhanced framework. Parties may register a CMC settlement as a CDRT order for faster enforcement if breached. An agency can issue mediation directions to require attendance in suitable cases. Now, as for the CDRA Act, which is in 2015, and the CDRT created a statutory court for neighbour disputes and established the CDRT within the state courts to hear intractable cases after mediation, and other efforts are exhausted. Focusing on interference with the employment or use of residents with policy emphasizing court as a last resort, and recent amendments streamlining processes and enabling interim and mandatory treatment orders for quicker relief. As for the available legal orders, the tribunal may grant damages up to 20,000 injunctions to stop conduct, specific performance to require actions, apologies, disbursements, and other orders needed to give effect to its decision. Applying a just and equitable test, guidance confirmed the damages cap, issuance via the Community Justice Tribunal system, enforceability of orders, and limited appeals with leave to the high courts. The CDRT can make tailored enforceable orders to stop harm, fix problems, compensation losses, and restore neighbourly relations, including damages up to 20,000, as mentioned earlier. Injunctions to cease specific conduct, specific performance to require practical corrective steps, apology orders to aid reconciliation, and ancillary directions to ensure compliance, all granted on a just and equitable basis after finding unreasonable interference, and typically used as the last resort following mediation attempts, with breaches enforceable like civil judgment, and registered CMC settlements treated as tribunal orders for swift enforcement. So, putting it together, begin with self-help and grassroots assistance first. Okay, proceed to CMC for mediation to resolve early and preserve the relationship with possible mediation direction and registration of settlements for enforceability, and only if mediation fails for serious and persistent disputes. File at the CDRT as the last resort, where strengthened tools target its effective, proportionate relief while minimizing long-term neighbours conflict.
Thank you very much, Katherine. That was a
Okay.
very detailed explanation of the whole framework. I think I would have one question from a member of in the audience. I think maybe I should direct this to Melvin. And the question is, how effective is CDRT? You know, that Katherine has just described. What if the respondent refuses to comply with the court order or the special directions? What more can be done? Should we criminalize neighbor disputes to give more powers?
Right, Ming. So I think it's a question that I think many may have about dealing with neighborly disputes. I think the answer actually does lie in just the construction of the question itself, because by going to the CDRT, which essentially is court, you're going through a legal process, and essentially when orders are issued, it's a court order. So if you don't comply with it, that there are issues with it. Obviously, there are legal consequences, and I won't belabor our audience with too much legal jargon, if you will. But the long and short of it all is that when you refuse to comply with a legal order, you can actually face, for instance, punishment that can also result in spending time inside, if you will. So it's important to realize that the amendments have come about at a timely juncture because there were concerns, I think, if we look at the whether you want to look at the introduction in terms of the debates through Parliament, as well as I would say the speeches that were made by the relevant stakeholders, and concerns about neighbours perhaps not showing up for mediation and also not complying. So what actually the amendments have done is actually given more bites, more teeth towards the entire process, not only I would say in the mediation process itself, but also in terms of the orders that the CDRT can issue. So just to hark back to what I shared at the beginning, the CDRT can now issue interim orders as well. It's not only when the matter's over that they can issue an order. So there certainly is more on the table in terms of what can be done when there are perhaps parties that aren't quite as compliant.
Thank you, Melvin. I have one more question at this point. Actually, the questions are coming in fast and furious.
Ooh.
But some of the questions I think we'll leave when we discuss the scenarios. We have some scenarios, and I think the questions will be answered. But there's one question here that maybe I would direct it to Katherine,
Sure.
with your experience in community mediation. And the question is, what are some resources available and accessible in the community for older adults who are not able to understand English but speak Mandarin or dialects?
Okay, this is not an issue at all. You can register your case with Community Mediation Center. Let them know that, the older folks require Mandarin, require translator, interpreters, what have you, and they will be able to find a suitable mediator for that purpose. So for myself, I do speak Hokkien as my dialect group. So sometimes I do mediation speaking Hokkien to the older folks. So of course, if there's Cantonese speaking ones, I believe we have a string of mediators who are able to do that. So not to worry, just put in your request to the Community Mediation Center. They'll be able to sort it out for you.
Okay, thank you, Katherine. I think we've got the time for two more quick questions from Melvin before we go on to the scenarios. And the first one is, if a neighbor refuses to attend the CMC, can we go directly to CDRT? Will the case be thrown out? And then the other one is that the CDRT process is very onerous, where we need to provide evidence that the noise nuisances comes from my neighbor, as the noises are occurring inside their unit. How can we do so?
Right. Those are good questions. I think the first thing to take note is that if you've already tried to engage your neighbor in mediation and tried to invite your neighbor essentially to come for mediation, and your neighbor still, in that particular scenario, refuses to come, I think if you were to proceed to CDRT, they will take notice of that, because it isn't as though you haven't tried the mediation. It's the other party perhaps that wasn't compliant with it. So I think that deals with the first question. That also cascades nicely into the second question, which is that of, the CDRT process, as you were saying, it's exacting. And it's rightly so, because the CDRT is a court a venue. It's a court procedure. So obviously, we would expect that if you're going through the court, then you need to provide evidence, which is something the court will be interested in, and I would say looking at when coming to a decision. So I would say, just as a rule of thumb, because I don't want to spoil it for our audience. I know we have scenarios coming up, but just as a rule of thumb, I think it's important to basically gather whatever you can, whatever you have. If it's to do with pictures, photos, videos, just laid out very generally, then you should try to gather those, because at the end of the day, when you go to court, right, which is the CDRT process, one more time, you want to be able to demonstrate, to persuade the court that this is actually what's happening, and that's the reason why you're seeking some sort of relief, whether it's through an order or otherwise in the court system.
Okay, thank you, Melvin. Just one more quick question on procedure. And the question is, how to file for CDRT? Do we have to serve it personally on the neighbor?
So, the wonderful thing about where we are in this day and age of our society in Singapore is that all the procedures can actually be found online. right? So if you were to go look at the judiciary.gov website and you specifically were to look for CDRT, it actually lays out all the steps there. But essentially what will happen is that if you were to proceed to file a claim through CDRT, your neighbor will be notified as part of the process. But therein also lies a problem, which is, I think, something that we will discuss more as we go along, which is you need to figure out who is the person that you suspect to be causing the noise. And when we live in very dense housing, as most of us do, sometimes it can be difficult. And the reason why I say this is because pursuing an action in court, there will be someone that you are suing or pursuing an action against, excuse me. So you need to know the identity of the individual. Otherwise, they won't know, they won't be served, as we call in law, for this. Yeah, and they won't be able to appear.
Okay, thank you very much, Melvin. I think we've answered quite a lot of the questions at this point. We should go on to look at the scenarios and then perhaps the other questions relating to some of the other issues will be answered then. So let's now look at some common scenarios encountered in real life. And let's begin with noise complaints. So the scenario is this. Mr. Lee suffers ongoing noise disturbances from his neighbor, Mr. Ang, who lives above him. The disturbances include loud dropping of dumbbells, jumping, drilling, knocking, and continuous dropping of marbles for over 2 hours on multiple occasions. These noises occur mainly around 5 a.m., disrupting Mr. Lee's sleep and daily routine. Despite repeated complaints, the noise has persisted for multiple years, affecting his well-being and peace of mind. And a related scenario, Mr. Lee also lives above Mr. Bo. Since early 2023, Mr. Lee has been disturbed by loud singing and music from Mr. Bo's karaoke sessions, often late into the night, disrupting his sleep even on weekdays. When Mr. Lee requested lower volume, Mr. Bo became hostile, leaving doors and windows open to amplify the noise and shouting vulgarities at Mr. Lee and his family. Mr. Lee believes these actions are intentional and have caused significant stress and tension. Melvin, from the legal perspective, we have a double whammy here. Does Mr. Lee have any grounds for complaint against his neighbors, Mr. Ang, who lives above him, and Mr. Bo, who lives below him? What would you suggest he do?
Well, I think the first and foremost thing to highlight is that it's quite unfortunate to be in Mr. Lee's situation. I think generally speaking, let's perhaps come back to the foundations of it all. When we talk about noise complaints, right? Usually relates to excessive noise, and that's actually regulated by Section 42A of the CDRA, which actually states that an act or an omission by a respondent which may cause interference with his or her neighbor's enjoyment or use of the neighbor's place of residence, and that may also include, and it's not limited to, for instance, causing excessive noise, smell, smoke, light and vibration, excuse me. So the reason for setting this context is so that we understand that if you were to take action, as we said earlier, it's about understanding what path Mr. Lee can take. So we are, of course, I would say, running certain assumptions that we know for sure that the noise comes from Mr. Ang, for instance, because I must say that in my own experience, both as counsel as well as a mediator, it's not always very clear where the noise originates from. But just to put things maybe simply for our audience, if we know for sure, or Mr. Lee knows for sure that it's Mr. Ang that's causing these noises, and he's really tried to essentially approach and speak to him, which actually should be the first thing that we all do as neighbors in order to resolve, to try to resolve these kinds of situations. Then he may actually try to escalate the matter, or I would say take further steps by trying to maybe have the matter dealt with in mediation, as we say, in community mediation, and failing which he can then, of course, try to take this through to the courts in CDRT. That's one way he could deal with it. I think the same approach should be taken when it comes to Mr. Bo as well. Again, running the assumptions that he knows that it is really Mr. Bo. I think all in all, when we talk about what can help your case when you bring the matter to CDRT, assuming, or even mediation, excuse me, you want to make sure that you bring, whether it's all your photos, your videos, your particular recordings that you have, for instance, to help paint that picture to whether it's the mediator or the judge who's actually, before dealing with your matter. It is also important to note that, if it's a situation whereby, for example, in the description of Mr. Bo's matter, where he's turned hostile, that we should also be careful. For instance, if there's any, I would say, indication that perhaps things might become a bit heated, and it might turn for the worse, for instance, then maybe you want to distance yourself from the neighbor and maybe not go up and confront that neighbor in that situation. I must also say that at this point in time, and I'm sure Katherine's gonna jump in on this very shortly, but usually the first triage, or the first, I would say, helpline is actually that of the grassroots leaders, who will actually be made aware of the situation, and they'll come in and try and speak to the neighbors and see whether they can resolve it, and then hopefully even refer them to mediation and so on and so forth from there. So the long and short of it all is, yes, the legal pathways are there, but that doesn't necessarily and shouldn't necessarily be the first thing that we go towards.
Okay, thank you, Melvin. Talking about mediation, let's now turn to Katherine. Katherine, in your experience as a community mediator, you must have come across such complaints before. What happened in these cases and how were they resolved?
We have many such cases repeating itself again and again, because where our community is very dense. But maybe I can share that perhaps the audience can remember this 5-step focus process, which I think is quite helpful for the audience. F stands for fix it yourself constructively. So there is no issue of personal safety involved. Just try to resolve the issue with your neighbors amicably. So the magic word here is amicably. Instead of threatening to call or calling the police or other government agency. So by not doing so, this will help to preserve the relationship with your neighbor. Second, O stands for objective. Isolate the problem from the person. Okay, address the offending behavior without resorting to personal attacks on your neighbor, and that is very important. Just focus on the issue. Communicate. Listen carefully to what your neighbor has to say without the need to defend yourself. So be mindful of your tone of voice and choice of words. That is very, very important as well. Don't be aggressive, okay? Be invested in understanding what is causing your neighbor's anxiety or frustration. Try to put yourself in the other person's shoes and see perhaps they are going through a bad patch in life. You never know, because if the door is always closed or slamming all the time, you wouldn't know what's going on behind those closed doors. And suggest solution. Don't just stop there. You have to, instead of engaging in a fault-finding loop, is your fault, you shouldn't do this, you shouldn't do that. I think we have to move on to find mutually acceptable solutions for you and your neighbor, and be prepared to compromise. Another magic word here is compromise. So you can't go into a discussion thinking that you will win this game. I want it my way or it's the highway. You can't do that. You have to go in with an open mindset and try and talk it out. So maybe you can get a 50-50 outcome or a win-win situation, and then I think you have it. We start taking baby steps first before we take bigger steps. So if there is a slight improvement, that means it's a good thing to start. Then perhaps as your relationship grew a little bit better, then maybe you can explore more solutions. So that's how you go towards. Now, I'm just going to draw some article here, reference, the Straits Times, 13 December 2017. Many a times everybody thought that the sound is definitely from upstairs, definitely from downstairs. We hear a lot of people complaining about this marbling, on the floor and all that. And there are some articles that say that sometimes when the neighbor goes out, the unit is empty. So what are the cause of those noises? So I'm going to shed some light into that by engineers. So structural engineers actually pointed out to two probable causes. First is the plumbing and the concrete walls and floors. Concrete floors may contract at night, giving off creaking sounds. So furthermore, sound travels and it is distorted as it passes through concrete walls and floors. One engineer said the sounds came from the plumbing in what we call water hammer. So water hammer occurs when water flow is shut off suddenly, like when the toilet is flushed. So this changes in pressure rattles the piping and creates a clanging sound, which may sound like marbles dropping after distortion through concrete walls. So these are some engineers that gave their feedback to a news article that we can take reference from. So it's not necessarily that, you know, your neighbor's upstairs is throwing marbles on the floor. Okay, so these are also depending on the medium that carrying the sound wave. So the sounds that we hear traveling through the floor slab above us does not necessarily mean that the sound originated from the neighbors directly above us. So such structures, especially in HDB, are reinforced concrete, which are very effective in allowing the transmission of noise. So sound can also travel via open windows, just like smoke. Okay, so sometimes you hear sounds at night. It could be due to the expansion or contraction of the connected materials. So for example, if steel or plastic pipes were connected or mounted on the wall or floor, movements can produce a noise that could then travel through the floor or wall, which could be heard further away from the source. So these are some things that I can share with the audience today so that you are aware. Sometimes noise could be from all these concrete and sound waves.
Wow, that's very interesting, Katherine. Thank you for sharing that. I'm very sure that many members of our audience would be glad to know that the sound of marbles rolling across the floor of the unit above late at night, especially empty units, are
Yes.
not due to
Mhm.
supernatural causes. That's interesting. And also your mention of focus,
Mhm.
right? That's useful. Those are useful points to note. I have one question that has been upvoted here from the audience, and it says, my new neighbor has a special needs child, I think, special child who makes loud, unpredictable shouting. While I am empathetic, it has now become a nuisance and getting unbearable. My neighbor is helpless too. What can I do? I think your focus, right?
I think it will still work. The neighbors, perhaps you need to speak with the parent of this special needs child and see whether you can work out a time schedule. So for example, I do not know whether are you a homemaker or you are working outside. There will be specific timing that maybe you can hear screaming, shouting, after office hour when you want to come home to rest and then the noise just keep on occurring. So perhaps I think you could approach the parents, the parents of the child and have a sit down discussion to see that, although I'm like what you have just said, I think is very subtle already. You can talk to them and see whether is there any way that you can put some dampening to the worst of in their house. That means those soundproofing nowadays for construction, there are a lot of those thickened soundproofing styrofoam. It's not, you don't call it styrofoam. Sorry, I can't remember the material. So there's a dampening material that specially provided for soundproofing. So maybe what you may suggest is to ask the parents to soundproof those rooms or wall. That would help a little bit. You can go and talk to them based on these methods and see how well they receive lah. Usually, I think they themselves are in the know. So they also, I believe the parents also wouldn't want to cause any disturbance to neighbors because then it will be very detrimental to the whole neighborhood. So I believe they will take this option and see, maybe try it out and see what happens after that. That could be one way to do it, to resolve these issues.
Well, thank you, Katherine. Yes, I have heard of soundproofing materials that you can buy and use to soundproof your own house, right? And I guess if the neighbor is not able to soundproof his unit, then I guess you can always soundproof your own, right? So that's a good suggestion. How about Melvin? Melvin, do you have anything to add to this discussion on noise complaints at this point? Is there anything else that you would like to add to the discussion?
I think the important thing to start with is that when we live in, these dense settings, it's invariable that there will be noise. I think that has to be the baseline. And sometimes when the noise, whether it becomes a bit unbearable or perhaps, in our own perspective, it might be a bit much. That initial conversation to have with your neighbor, I think it's very important, because at the end of the day, even if you decide to pursue whether it's mediation or perhaps through the courts, you pursue a legal procedure as well as remedy and outcome, most of us, just generally speaking, will have to go back and still live where we are, and our neighbors will still be there. So at the end of the day, it's always about ensuring that we try to go about it in dealing with a situation in a way that allows us to perhaps still have a livable situation, if you will. So I would be slow to perhaps say, if talking to your neighbor doesn't work, you should straight away go to a legal solution or seek a legal solution. I think sometimes it's really just trying to understand a bit more about each other's situations. I'm sure that the neighbor themselves are also trying to do their best. I mean, I'm obviously assuming certain things. But at the same time, if that conversation should be the first step, and if really it doesn't work and you wish to, escalate the matter further, you can. The one thing that I always invite parties to think about, whether it's in mediation or through the court process, is, what is it that you want out of this situation? And sometimes if we kind of make things a bit more difficult, if you will, to try and reach a resolution, and reach a solution, and you still have to come back and live next to your neighbor, right? It might not be good for everybody in the long run, which is why I emphasize the point about having a sustainable and workable solution at the end of the day. Yeah.
Okay, thank you very much, Melvin. Let's now look at a couple of scenarios involving excessive smoke. So for our first scenario, Mrs. Priya lives in an HDB flat next to her neighbor, Mr. Raj. For some time, Mr. Raj has been smoking outside his unit, and the cigarette smoke drifts into Mrs. Priya's laundry area. This causes her clothes and linens to smell of smoke, and also affects her family's health as they have respiratory sensitivities. Around November 2024, Mr. Raj appeared to reduce the problem, either by smoking less or by smoking elsewhere. However, in the past 3 days, he has resumed smoking heavily outside his flat, and the issue has returned. Mrs. Priya feels that the cigarette smoke is an unreasonable disturbance to her household. And the next scenario we have involves Madam Tan, who lives above Mr. Ahmad in an HDB flat. Smoke from Mr. Ahmad's kitchen window and corridor frequently drifts into her flat, affecting her kitchen, bedrooms, and living areas. Her toddler, who has asthma, often coughs and has trouble breathing whenever the smoke enters their home. The family has tried using air purifiers and keeping the windows closed, but the smoke still penetrates the flat, especially in the evenings when Mr. Ahmad smokes multiple times. Madam Tan is concerned for her child's health and is seeking a resolution to prevent further exposure. Melvin, what can Mrs. Priya and Madam Tan do about the smoke in their situations?
So, smoke, much like noise, unfortunately, it doesn't stay contained within the area where it happens, right? I think when it comes to smoke, and specifically in the scenario that we have just explored together, there is a concern about health and how it will affect, the residents of the apartment. So again, the same pathway still applies, which is try to have a conversation with your neighbor in terms of trying to get your neighbor to perhaps smoke within his house. Because right now, from what I can see, Siraj is the one that's actually smoking outside his house. Because what you do within the confines of your house, I mean, obviously subject to some limitations, you can actually go ahead and smoke there, right? Because it is your place. The issue is now what happens when it starts affecting your neighbors around you. If the conversation is had and it still doesn't work, then similarly escalate it through mediation through your grassroots leaders, of course. And then if the incidents still carry on and maybe even intensify, multiply, if you will, my suggestion would be to note it down and to, perhaps, what I always say to parties who are unfortunately going through this situation is make sure you keep sort of like a timeline, whether it's an Excel sheet or otherwise, about each date and time about things that have happened and how you've tried to resolve it. And yet, perhaps in this particular case, the neighbor still persists and it actually affects, there's actually potential damage that's being caused to the health of the family members and whatnot. Because those are things that when the matter unfortunately has to go to court, those are the things that the court will be interested to look at. So just as a reminder as to the provision in the Community Disputes Resolution Act, it's about excessive in this particular case, excessive noise. So it can't be a one-off incident. It has to be basically many times and it's somewhat overwhelming as well. So that's the reason for noting it down so that you can paint that picture, demonstrate as to how serious the situation is. So from a legal perspective, those are the things to take note. And I would say that one of the remedies that the family that, for instance, Mrs. Priya or maybe Madam Tan, right, will want to pursue is for him to perhaps stop doing what he's doing in terms of smoking outside, and then for him to do it inside his own home. So that's from a legal perspective.
Okay, thank you, Melvin. Katherine, what other advice can you share?
Smoke is a tricky issue because you know how stringent the government is regarding about smoking outside, throwing cigarette butts outside and all that. So many resort to smoking at home. So then the neighbors come into play now, because the smoke is affecting them. They are breathing in secondhand smoke. They have young children running around the corridors and all that. I think being considerate as an individual is very important as well. Take it as if the person has kids themselves, they wouldn't also want the kids to breathe in the secondhand smoke. But of course, don't go in that direction when you approach your neighbor who is smoking. So I think, again, CMC is set up just to ensure that such matters are resolved amicably. So sometimes parties settles with terms like reducing smoking frequency, adopting measures to prevent smoke drift, and agreeing on direct contact if problems occur. So there were 8 cases that reached mediation in 2015 to 2017, and it settled successfully. So early stages success also via joint advisory. Agency often first issue a joint advisory on smoking in homes, so prompting the smokers to adjust habits. So between 2019 and 2021, many of 50 excessive smoke CDRT filings were resolved amicably, so redrawn or by consent, reflecting the effect of advice and mediation before full hearings. So I think is a cordial way of approaching the matter. I believe this can be resolved as well since it has been proven from CMC settlement rates. Yeah.
Okay, that's good. I'm glad to hear that those cases of smoking that went up for mediation were settled, were resolved successfully. Let's now look at a couple of scenarios involving hoarding. And that's another perennial problem. So we have the following scenario. Madam Aisha lives in an HDB flat and has ongoing issues with her neighbor, Madam Lim. Madam Lim keeps numerous potted plants and gardening items along the common corridor, blocking the passage. This makes movement difficult for Madam Aisha, who uses a walking frame, and creates a safety risk in case of emergencies such as a fire. Despite repeated requests, Madam Lim has not removed the items, causing further tensions between the neighbours. Turning to Melvin again, Melvin, can I first invite you to set out for us the law regarding hoarding?
Right. So the law regarding hoarding is actually found in the same provision as what we mentioned earlier. And specifically, if I were to drill down on what the wording is pertaining to hoarding, it's actually about causing interference with the neighbor's enjoyment or use of place of residence. And in this particular instance, referring to the situation of Madam Aisha, it is that of obstructing the neighbor's place of residence by placing anything or object by any other manner or at or in the vicinity of the neighbor's place of residence. So essentially, if you were to do what what's being done is as per described in the scenario, then technically it might constitute an offense in terms of interfering with the enjoyment of your particular property.
Now, Katherine, would you like to add to what Melvin has said?
Hoarding along the corridor is a strict no because there's fire hazards involvement, and you're not talking about your family life, you're talking about your neighbor's life as well. So plant hoarding, although there are some older HDB corridors, they are wider, but you are supposed to keep like at least a 1.2 meters width for easy clearance. So hoarding is definitely not encouraged. And then with the CDRT coming in and the enhanced framework, we can take comfort that this will be looked into quite seriously. So they will be asked to remove all the planters plants if it's all over the corridor, because this is a fire hazard. Once the plant gets fire, somebody smoke from upstairs, throw the cigarette butt down, fly into one of your potted plants, it catch fire, everybody's life will be at stake. So this is very, very dangerous. And of course, we need to be very careful when the potted plants are all over and overgrown and eating into the corridor space. So that is, of course, not allowed to. And if I may share, there are always, audience asking, oh, who should I call? Town council, police, and all that. So let me just give you all a heads up on some of the places or agencies that you can call if you require some help. For example, you can report via one service for HDB Town Council. And then the Hoarding Management Core Group, MSO-led, coordinates HDB, NEA for pests, SCDF for fire, AVS for animal hoarding, and town councils for common areas. So these are some of your guidelines that you can go to. But of course, we also have this added social health support via AIC, IMH, FSCs. So try CMC mediation first for cooperative fixes. If severe and unresolved, then the new framework, which is still in the pilot stage, I must say, the CRU may then step in and as a last resort seek CDRT orders to declutter or abet risk. So that is some light at the end of the tunnel if let's say that your neighbors are hoarding the entire corridor with beautiful plants.
Well, thank you very much, Katherine. That's really interesting to know, especially that 1.2 meter rule. I think that is a useful guideline. Now, let's look at a slightly different scenario, which will be our last for tonight. Mr. Kumar's neighbor, Madam Wong, keeps stacks of flattened cardboard boxes in her flat and in the corridor outside her flat, and even further along the corridor past her flat. This obstructs movement for other residents, especially when carrying groceries or pushing a stroller. It blocks emergency access and increases the risk of knocking into these items while walking. Despite polite requests, Madam Wong has not found a way to minimize the obstruction, saying she wants to sell the boxes to Karanguni men. Mr. Kumar has started to throw away some of the cardboard boxes and has been caught by Madam Wong doing so on a few occasions, leading to loud arguments between them. Melvin, can you shed some light on what would be the legal position in such a scenario?
I think the situation is one whereby obviously we know that hoarding in this particular setup interferes with your neighbor's quality of life as well as their quiet enjoyment of their property. So we know that that is already an issue in law. The other thing that I wish to point out in this situation is there is a provision within the same act of the CDRA itself, which is interfering with the neighbor or the neighbor's movable property, right? Either at or in the vicinity of his place of residence. So the long and the short of it all, and how this applies to all of us in daily living, is you shouldn't be touching or throwing away your neighbor's property, even if you agree with or disagree, excuse me, with how and where it is being placed. Because first, legally there might be an issue. The second, it would probably lead to some sort of unwanted situations or confrontation, if you will, with your neighbor. And if tensions are already running high because of, I would say, the repeated conversations, to put it very generally, between yourself and your neighbor, that we should try to avoid, escalating the matter that way. Kat has really very kindly pointed out that there are various avenues that you can go, whether it's through the One Service app or otherwise, to alert authorities to the situation. Let them be the ones to essentially issue notices if need be to remove the items. They usually would come, for instance, in HDBs, and if really there's excessive hoarding, the respective agencies will actually come and actually issue a notice. They usually will paste a notice on the wall to say that this is the situation, and they will inform the neighbor to remove the items within a particular period in time. Otherwise, the town council, for instance, will come and clear off all the items. So don't put yourself in the situation whereby you are the one that actually is throwing things away, because then, two wrongs don't make a right, and then, it might just create unnecessary or add to unnecessary tension in the entire matter. The other thing I want to also point out is that a key issue with hoarding sometimes that isn't spoken about enough when we deal with these scenarios in the legal context is that they are potential fire hazard. And if, unfortunately, touch wood, right, a fire breaks out, all of these things that are around actually just contribute to flammable materials that will cause the fire to keep going. And maybe it's the legal training in me, but I'm really thinking about liability if this thing kicks off and unfortunately deteriorates along that path. So again, not touching it and not being involved with moving the items around, and basically deal with it properly. Inform the authorities and let them deal with it. Obviously, that should be the way about dealing with hoarding. Yeah, that's my take on it.
Well, thank you very much, Melvin. I think that is very good advice for our audience members not to take matters into their own hands, but to go to the authorities, right? And then in this case, that would be to approach the grassroots leaders. Am I right, Katherine? And maybe, seek mediation?
Well, I have a different thoughts on this. Of course, CMC is one way, right? But I have a different thoughts on this. Let me set a scenario. Just imagine Madam Wong is a very old lady. Okay, so all white hair and all that. Now I will empathize. I will think that I will speak with her first and have an understanding why is she putting all the cardboard stacks outside her house. So for all you know, she may say that, she doesn't have the contact detail of the Karangoni man, or she doesn't know how to get rid of them, or she doesn't know how to sell them away, and all that. The list goes on, right? I'm just setting a scenario. I'm not saying that this is happening, okay? So I think Mr. Kumar, if he can approach Madam Wong and say, I understand that you are selling this away to earn a living and all that. Maybe I can help you, to sell it or give you a contact detail. So in that way, you already created a neighboring feelings between, the neighborhood, right? And then you will get into a good books. So you give her the contact and then you say that, why don't I help you facilitate the contact? Let me call the person for you, then hand over the phone to her so that she will also not be suspicious, don't know why is he what is he up to? Why is he so kind to me? Why is he, helping me to make the call and all that? But actually, there is also investor interest. That is to clear the hoarding situation. So maybe by doing so and with regular cleaning up of those carton boxes, it solves your problem. So sometimes mediation provide that space, that platform for you to explore and ask questions, because sometimes that old lady is having issues by not able to know who to call, or maybe she only have that one contact, and that one contact could be a older individual who is not able to make frequent trips to her corridor to pick up all these loots that I call them loots. So I think that is one way. If you do have neighbors who are hoarding and you know that they are doing it for a business, maybe that is one way that you can just ask them nicely. Okay, the magic word is nicely. Don't intimidate, don't threaten. Just ask them, maybe I can help you. I think that kindness may turn into something bigger. That's how I look at it. Yeah.
Great. That's great, Katherine. I think that's a good approach.
Mhm.
Let's turn now to some of the questions submitted by the audience. As a reminder to our audience, you can still submit questions through Pigeonhole or upvote those that are already there. Our first question is, Melvin, this question is for you. And talking about items being removed, the question is it legal to install a camera at the main entrance of a HDB unit to prevent delivered goods and pots of plants from being removed without consent? Thank you.
So I think this particular question is something that that comes up pretty often. First and foremost, to highlight it, the main thing that we need to consider is when you are installing the camera, where is it going to be? I mean, obviously, it should be within your house. That's the first thing, and the other thing is, where is it facing, right? Because it shouldn't be, a camera that basically looks into your neighbor's house. Yeah, I mean, that's one of the key concerns. So if you're installing a camera within your own premises and it's perhaps only directed at your doorway, for instance, it doesn't look into your neighbor's house and whatnot, that should be fine. Okay. Anything more than that, right? I would say that it's something that, especially when it comes to public housing, it can only be done with the approval of the relevant authorities. So that one you have to go and seek approval to do so. I think it's quite common these days to have cameras installed. So I think that's something that our audience members should bear in mind, because if the purpose is that of, I would say, looking at the parcels when they're delivered, then your camera doesn't need to be looking down the entire hallway, for instance. It only needs to be looking at your doorway. Yeah.
Okay, thank you very much, Melvin. That's very helpful. I've got another question for you here.
Mhm.
And this one is a bit, I hope you can answer this. Is, can the CDRT issue a protection order for me after I file a claim? I am worried my neighbor may get aggressive towards me.
Okay, this is unfortunate, but the CDRT doesn't actually issue a protection order in that way. Usually when we speak about protection orders, it's to do with instances whereby it's to do with family members, for instance. So that's usually that's the situation in which protection orders are discussed. I think if it's a situation whereby you're concerned that when you take or you pursue a legal action against your neighbor and perhaps there's some grievance or unhappiness, the venue is not, or rather the option and the particular solution is not a protection order. I think it comes back to what we said from the beginning, which is that it always starts with having that conversation with your neighbor first to try and see whether we can resolve this. And you're only pursuing legal action subsequent after mediation because there's no resort. And if at that point, unfortunately, it comes to a situation whereby, there's particular hostility that results in perhaps some sort of threat against you, then that would be the time, I would say, to make a relevant police report. It's only at that stage. It shouldn't be like the first thing that you realize that, or you think that your neighbor's being hostile and I'm going to go straight to file a police report. But again, I'm tempering all this with the understanding one more time that it is not the first port of call to immediately confront your neighbor. When you start speaking with your neighbor, the intention is not confrontation. It's to, like what Kat mentioned earlier, it's in terms of good neighborliness, is to try and demonstrate goodwill to try and resolve this situation, because more likely than not, you will be continuing to live with your neighbor next to you. But yes, your avenues towards the authorities is available if it really comes to it. Yeah.
Great. Thank you, Melvin. One related question, and that's on CDRT and magistrates' complaints.
Mhm.
Which is more effective, and how about the cost?
Right. I'm gonna end up wearing my criminal procedure hat right now. So the functions are different, right? A magistrate's complaint is literally you are complaining before a magistrate who's a judge. And it's a situation whereby, for instance, just hypothetically, you've lodged a police report. The police have told you that they're not gonna basically be pursuing the matter, or they referred you to the courts to say, let's go for a magistrate's complaint. And when you go for a magistrate's complaint, you essentially are telling the court that you want to, for instance, prosecute your neighbor, or you want the court to direct the police to investigate further. So there's a few things that can happen in a magistrate's complaint, right? It's either they can tell you, no, you can't do anything. They just dismiss the matter. They can direct the police to go investigate the matter. They can also, decide, having looked at the matter, that, they will grant you with the particular agreement and authority of chambers, Attorney General's chambers, for you to prosecute in the matter as well. There's also one other one in which they can direct you for mediation in the courts. So either in each of those situations, apart from the one where they basically tell you to go fly kite and say that there's nothing to be done here, you are still essentially trying to prosecute or take action against your neighbor. So there is a criminal element in it, or quasi-criminal element in it, at the very, very least. Or at the very least, you're also seeking some sort of civil remedy against your neighbor. So that is not confined to only neighborly situations or disputes, right? That's quite different from the CDRT. By its very name, the CDRT is meant to deal with community disputes. So to that extent, it's going to be taking that look at the relationship between the neighbors and try to see whether we can work out some sort of arrangement, right? It could be an arrangement whereby essentially a stop order is needed, whereby just stop doing what one particular neighbor is doing. Or it could be a specific performance whereby you're telling a neighbor do something, right? Maybe to remove something, if you will. So I think the functionality is very different. It's not whether one is stronger than the other. I think it's about appropriateness. So if it's a community dispute, the CDRT is the avenue that you're looking for, because you're not looking to prosecute your neighbor. I mean, I'm making certain assumptions as well. But if it's that to seek resolution of the situation between you and your neighbor, then the CDRT is the more appropriate venue to go. I must also highlight, and I think it's full disclosure, it's not only because Kat and I are mediators. The CDRT can also direct you for mediation as well in order to resolve this. So it's not always going to be you go to them and then it's just issuing an order. They could direct you for mediation if appropriate to resolve it as well.
Okay. Thank you very much, Melvin. That's a interesting, insightful answer. So it would appear that the trend would be for more mediation and less litigation. Would it be right to say that?
Hopefully, I think that
Certainly.
yeah. I think we both have vested interest in this because of course I'll speak from my own experience. I'm sure Kat will add on. There are many situations that can actually be dealt with appropriately if people just have a conversation with one another, and that's not only necessarily only in a neighborly situation. But one of the more interesting things that I've realized, and especially with perhaps as time has gone by, is that many of us don't actually even speak or know our neighbors' names. And that's actually a useful starting point, because when you don't know the person that you're dealing with, you may make certain assumptions. And sometimes in mediation, in community mediation, when they come for mediation, that's actually the first time that they're actually seeing and talking to one another. So yeah, I would be very hopeful that mediation would be the preferred way going forward. But Kat, anything to that?
You need to understand CDRT, what it does. So it is a judicial tribunal, okay, that adjudicates neighbors' dispute as a last resort, not first resort. So I think they will still direct you to a CMC mediation first. Until that fails, then they probably will come in as a last resort and issues enforceable legal orders after parties have attempted mediation. So one of the things that the enhanced framework is also you are able to convert your or CMC mediation settlement agreement to CDRT as like a binding document as well. So that is also upcoming. So look out for that as well.
That's good to know. I see that we've got more questions coming in. In fact, the number of viewers that we have right now is much more than at the start of our webinar. I think we've still got time for some questions.
Sorry, can we jump in here?
Sure.
Because just now, earlier on, one audience asked about the panel, the noise regarding about a special needs kid. I managed to find that out for you. It's called the mass-loaded vinyl, or it's also called the acoustic plasterboard. So you can go ahead and find out how do you get your hands on this. And so when you make your recommendation, you have all this information ready. At the same time, I think there are nicer acoustic panels that is, you've seen in some of those corporate offices that they will try to insulate the noise within their office. Usually you see a lot of that in law firms where they try to mute the noise from coming out from that room. So it is quite beautifully done up as well, those panels. So it's just like a molded panels to suit the design of your house. So if you are able to Google them a little bit, that you have the names for those acoustic panels, and then maybe approach them and see whether would they be keen to install those panels into their household.
Well, thank you, Katherine. That's really useful information. So acoustic panels, I will go and Google that later myself. Now, turning back to the issue of smoke. This question was upvoted and it says, my neighbor's smoke flows into my house. Others said they also suffer the same in Facebook estate group. So we have young kids and don't want our lives shortened. Smokers start at 4 a.m. till 11 p.m. and refuse to compromise. Melvin, what would you suggest in that case then?
So I guess I mean the plan is always the same, regardless of whether it's noise, whether it's smoke, and so on and so forth, right? Which is you try to have the conversation first with your neighbor, and if you have the conversation and if it goes well, and you are able to reach a compromise, then great. Sometimes what happens is that the first conversation or the first few conversations maybe doesn't really quite have that lasting effect, and you need to try and be consistent and follow up and to speak with the particular neighbor in question and see whether they're willing to do anything. So that being said, I think the situation that's been described in this question is one where the conversations have already been had and they've tried to ask the neighbor to stop, but perhaps the neighbor won't. I will think that the next level will be to try and get the grassroots leaders involved, because if the neighbor speaking directly to the particular party isn't working quite as well, then you actually do need a third party to come in to try and, using the term very loosely, mediate the matter to see whether or not they will, perhaps empathize with the situation when it is someone else telling them about it. And again, of course, if really it still doesn't work, then you just have to push it along, and maybe you would basically apply for mediation, if the community mediation center, for instance, if that is necessary. And if that doesn't work still, then you can pursue the route through CDRT. But like what Kat mentioned earlier, it is the last resort, I would say, because if at that stage, and nobody likes to get a notice from court to say that you have to appear in court, essentially. So yeah, but if it comes to it, then by all means, that's the whole reason why the CDRT was set up. I think it is also quite interesting that when we talk about severe noise and smoke, if you will, it's a concern that it's common and it's not that easily dealt with all the time, right? So ultimately, what I would say is that if it really is affecting your health or your family's health negatively, and it's not just one family, like what was mentioned in the scenario, then maybe more needs to be done. And sometimes when we say more needs to be done is then the legal route needs to be pursued, essentially.
Okay, that's a very detailed answer. I think it reinforces what you've been saying so far, right? And that's a consistent approach. I think one question for Katherine, which is these scenarios are set in blocks of HDB flats. But what if they occurred in a private apartment block? Are there different avenues for help?
Well, you can approach your MCST first and foremost. Ask your estate manager to be involved and let them know the situation. I believe we are able to help you at the first stage, approaching the neighbors first. Then, secondly, if there are more than one complaint and all that, MCST can see how they are able to put certain gadgets or whatsoever. It all depends whether the committee are all for it or not, because it's very much run by the MCST themselves. But of course, you are still able to register these issues with CMC, but then we will probably have to ask you to involve the MCST, because we will need to know whether what actions has been taken before you come to CMC for this mediation.
Okay, that's good. Melvin, how about private housing estates? Would that be different?
Well, I presume we were speaking about perhaps like landed
properties, yeah.
Yeah. I mean, still, I mean, it's still the same in terms of, try and speak with your neighbor. And unfortunately, if it doesn't work, because it's not in a HDB setting, you can't go to the town council, for instance. You may actually have to try and escalate it even quicker to the legal process in that sense. It is ironic that I'm saying this because as a legally trained person, but it is not ideal to start writing or sending lawyers letters as soon as maybe this is going to be detrimental for practice. But the point really is that really try and have that conversation, and if really it doesn't work, then unfortunately you just have to try and seek mediation. And mediation doesn't always only happen, for instance, at the community mediation center. That's one avenue. Kat, myself, for instance, we do conduct mediations in different settings. For instance, private mediations, whether with organizations or in our own entity as well. So the point really is you can seek those means of trying to resolve the matter without, I would say, starting to sue people, your neighbors, unfortunately, in order to get a resolution. The other thing that I will also add, Ming, is that if mediation doesn't work out, for instance, in private mediation, the situation that we're talking about, you are still free to pursue your legal remedies through the court as well. So you may want to consider having that conversation sooner rather than later, especially when it comes to private housing estates, as we were just speaking about.
Okay, thank you. Yes, I think the private housing estates maybe that would be a different case from the scenarios that we've been looking at, and where you might have to escalate it to the legal option, right? But I've got a question here, and that is, when can we apply for personal protection from harassment? What if it escalates to verbal abuse or the use of vulgarities, right? Can such verbal abuse or use of vulgarities be considered as verbal harassment? Would this be a criminal offense? Would this be something that should be escalated to the legal route instead of through mediation? What do you think? I'd like to hear from you, Melvin, and then maybe Katherine can share your thoughts on that.
I think it's a good question because it's twofold. Because you can deal with the situation in mediation, because if the parties agree that they will stop doing what they're doing, and they can come to an agreement, like a settlement agreement, to say that, whatever actions beforehand, they will stop doing it. Sometimes they even need some sort of, I don't know, remedy or recognition, and that may come in the form of, whether it's a apology or otherwise, for instance. That can also be dealt with in mediation, and the matter just ends there, right? That's also possible. But sometimes for parties that perhaps that have been enduring this situation for a prolonged and protracted period in time, at a particular intensity level, they may feel that they need to go through the legal process in order to have that sense or day of in court or justice as well. So, yes, if it really is a repeated, excessive situation whereby all these abuse, if you will, or harassment or particular insults have been done. I mean, sometimes it's in person, sometimes it's even like through social media in this day and age. These can actually fall within the category or the understanding and definition for POHA and harassment purposes. I do have to point out again, it cannot be a single one-off or one or two times, for instance. For POHA, it's a situation whereby it's repeated. So yes, they can, but I wouldn't be so quick to necessarily rule out mediation, because sometimes when parties are brought to the table to have that conversation, the supposed offending party realizes the extent of the harm or the wrong that they've been doing, and they would, as part of trying to put it in the past, they can actually come to an agreement to set it aside as well.
Okay. How about you, Katherine?
I think it will be a different story if assuming one of the parties are mentally unstable. This will throw the whole conversation off. Am I right, Melvin? Because mental health issues cannot be dealt with in this manner, because I think they need help lah to begin with, because they are mentally unstable. That could start off keeping repeatedly verbal abusing, verbal harassment. Sometimes it can be quite torturous to the recipient themselves or the victims themselves. So having said that, right, this will probably need some intervention. I do not, for the CDRT, sorry, I think there is this segment where they will come in, if assuming that we do find that one of the party is mentally challenged. I think they will come in to help you resolve the issue, because I think that particular disputant or party require medical help for their mental health. So it is quite different, when you are dealing with mental health individual.
If I could also add on, Ming, I think we have to be very careful when it comes to, for instance, suspicions of situations whereby perhaps one of the parties has some sort of underlying condition. I speak for myself. I'm not a licensed doctor to be able to diagnose. I think sometimes you may have some suspicion that perhaps the issue might be one that is more serious than I would say it can actually be encapsulated or dealt with in a single mediation session. So in that kind of situation, I think as neighbors, first and foremost, we have to be a bit more understanding. And at the same time, also appreciate that perhaps we need help from other agencies and authorities in order to cope with the situation. It's not something that the two parties can just agree between themselves and it will go away as well. Yeah.
That's a very good point, Melvin. I think maybe it's worth noting also that we should not conflate mental health with like special needs or autism, right? Which is a totally different thing.
Different.
But talking about mental health, I seem to recall the figures that 1 in 5 or 1 in 6 Singaporeans have some form of mental health issue, but that could be just depression or eating disorder or something like that. So mental health could be quite wide, and it's, I think, very useful, as you said, to think about these issues also. I think we are running close to the end of time. I think there have been some other questions. We can't answer all of them. There is one actually that was a bit upvoted, and that is loud noises and shouting coming from the basketball court or the pickleball court, the hard court, right? I think the question is loud noises and shouting from the court. I don't think they mean the legal court. So I called the police, and the police say that it's the town council. Town council says it's the HDB. HDB says it's the police. So who is responsible? Would either of you like to give some advice there?
Well, it's always this, I refer to you, you refer to me, right? Well, one app, one service app, but it depends on the timing as well. So be mindful that we are supposed to be aware of the time that you're not supposed to create noise. That is from 10:30 p.m. all the way to 7 a.m. the next morning. So now, if the basketball court is having a lot of noises from the kids nearby or whatsoever, you have to see what time is it. Because if it's anything after 6 p.m. and the lights are still on, because I understand the court's lights are usually on until about 9:30. I think so. I'm not quite sure myself. Those time you can't be possibly calling a town council because they will be closed. Their office is closed already. So naturally you will be the police, because the police will then have to go down to investigate. So imagine if you keep that question for the town council, by the next day you will not be able to make any arrests or tell the group of people who's making a lot of noise to keep quiet and keep their tone down, right? So it will still come back to the timing as well. So you look at the timing. If it's anything after 6, then you go to the town council for noise issues, noise related issues. I think that includes the void deck, if I'm not wrong. So if you have void deck nearby badminton court, basketball courts and all that, then you take note of the calls that you need to make to these relevant agencies. But anything after 6, I think police is the way to it, because they can act on it quickly and investigate.
Okay, thank you, Katherine. That is a good guideline. Good point that after 6, the town council's office is closed. But you also said between 10:30 p.m. and 7
To 7
a.m.
a.m. Yeah, that's
that
where
should
we have
not-
to be quiet.
should be quiet,
Yeah.
right? So maybe if after 6, between 6 p.m. and 10:30 p.m., if the lights of the court are still on, then that's probably a legitimate use of the court. What do you think?
I think, but I mean, these things are usually set to automatic timers anyway.
Right.
They turn off by a certain time, just like the lighting in the
Yeah.
park,
Right.
for instance.
Right,
So
right.
I don't think there's an issue. I think perhaps, I mean, I'm extrapolating here and going a little bit further, but I suspect it might be the noises that are being caused in this court when people are supposedly trying to sleep. I think that's the problem.
Ah,
Yeah. So obviously, if you were to escalate the matter or take a photo or video, even you send it through the One Service app, I think to add on to Kat's point, by the time authorities come, it'll be over. Yeah. So, yeah, that really is the situation.
okay. We've got time for a couple more quick questions. One question that has been upvoted a lot is how to educate persistent littering from high floors to move the MP or to make a police report.
You can do either. You can go to the MP and you can make a police report. I believe if you go to the MP, I think they are able to escalate it to some agency. Then there could be some cameras to be placed on strategic location around the block to catch the litter, the guy who litters. So I think you are able to do that. Go to your Meet the People session, grassroots and all that, to seek help. They are able to facilitate some form of video recording for litter bugs, so to speak.
I think it also helps that littering is a criminal offense.
Yeah, it is.
So I mean, you don't want to fall afoul of the law. So that obviously can lead to
Arrestable. Arrestable.
yes, and also, I mean, I wanted to say getting the police involved in that situation.
Mm.
Yeah.
Okay, that's good. That's good. How about this question now? Should we criminalize such nuisances under the Miscellaneous Offences, Public Order and Nuisance Act?
What offenses specifically? Anything?
I guess if we're talking about like noise, littering, vulgarities or smoke, would these constitute a nuisance?
Okay, so I think perhaps the way to approach this is that in particular given situations, these acts can constitute offenses already. I think that will probably be the best way that I can put it. I think when we're dealing with our situation now in the community setting and that of neighbors, we have to be slow to criminalize acts. And the reason is because you don't want a situation where there's active hostility between neighbors, because whether it's an unhappiness or misunderstanding. I think it's very, very important that, and it's the reason why, again, it's not only because we're mediators, that's why we keep plugging communication and mediation. The reason why we keep talking about it is because ultimately, at the end of the day, if the situation can be worked out between neighbors and we don't have to escalate it any further or get authorities involved, whether police or the courts, then it actually works out for the greater social good. So the concern, at least from my perspective, or the perspective that I'm sharing, is that it shouldn't be about criminalizing or putting more things in the law to say that, if you do this or you don't do this, you'll be liable. But it starts with, I would say, that right mindset and the right heart, if you will, about trying to be human with your neighbors and try and talk things out where necessary, and only if it really is that extreme, and then we pursue the legal route. I mean, that's the whole point that I would say you have the community relations unit that was started to deal with very severe cases. And it's not like in every instance or in a knee-jerk reaction that we're going to have all these actions or orders carried out. It really is for select cases that really need that intervention. So again, we should be slow about criminalizing each and every act in that way as pertaining to neighbors.
I agree, especially since you as a criminal lawyer, if you feel that way, then I guess that must be the right approach. Now we're running out of time, so now I would like to ask each of our speakers to leave us with one key takeaway. Ladies first. Katherine?
Oh, it's me. So focus. Remember the word focus. Let me just highlight one more time. Fix it yourself constructively, objective, communication, understanding it, and suggest solutions. Everything, watch your body language and the words, the choice of words you use when you're talking to the other person. That will go a long way.
Thank you. That's very helpful, Katherine. I think that's something that we should all remember. Focus. How about Melvin? What's your key takeaway?
My key takeaway is it's something that hopefully I've been consistent about in sharing in this session, which is that whenever you think or you encounter what you suspect is a situation that you have with your neighbor, reach out and have a conversation first before deciding, what to do next. Because sometimes it's in that conversation that you figure out, the situation. And sometimes your neighbor may not even realize that it's an issue until you have that conversation. And if I could just say one more thing, because we're on a PBSG particular webinar, I just wanted to point out that if there's any help that's needed, you can always come to Pro Bono SG and you write to us at help@probono.sg if any assistance is needed.
Okay, that's very good. help@probono.sg. All right, thank you very much. Katherine, any last words?
No. Thank you for having us here tonight.
Okay, well, we have to bring our Q&A session to a close in that case. Our next webinar will be on social media and the law, Post with Prudence, which is happening on Wednesday, 1st October 2025 at 7:30 p.m. The session will explore data protection obligations when handling customer information on social media posts, best practices for engaging influencers with clear terms, key regulations on social media marketing, and advertising standards in Singapore, how to manage customer reviews and feedback responsibly, and common pitfalls to avoid, such as defamation, harassment, and copyright infringement. So whether you are a content creator, small business owner, community organization, or social media professional, this webinar will equip you with the knowledge to post with confidence and prudence. So this and many more webinars are part of Law Awareness Weeks at CDC 2025. You can scan the QR code or visit the website https://lawarenesweeks.cdc.gov.sg to register for the next webinar or the many more webinars available. And if you wish to watch this webinar again or catch the ones you missed, the recordings of all the Law at CDC webinars will be made available on Pro Bono SG's YouTube channel 2 weeks after the end of the live webinar. You can check out the channel on YouTube. The link will be dropped into the chat function. Now, at the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments, as it will be used to improve future webinars. Now, after today's fantastic sharing from our panelists, if you find that you require legal guidance on your legal issue, do write to help@probono.sg, as Melvin has pointed out. And lastly, we would like to express our gratitude to Melvin and Katherine for sharing their knowledge and experience with us. So with that, on behalf of Pro Bono SG, thank you,
Thank
Melvin and Katherine.
Thank you. Thank
Thank
you.
you, Ming. Thank you. Thank you for
you.
having us.
And we would like to thank all of you for joining us today. Have a good weekend ahead. Thank you.
Good night.